Welcome to episode 32 of the Supreme Court Opinions Read podcast, where we read Supreme Court opinions so you don't have to. My name is Bailey, and I'll be reading the Supreme Court's opinion in Urias-Orellana versus Bondi. The case was decided March 4th, 2026. And as always, we'll start with the syllabus. This case presents the question whether the Courts of Appeals must apply substantial evidence review to the Board of Immigration Appeals' determination whether a given set of undisputed facts constitutes persecution under 8 U.S.C. Section 1101A42. Petitioners Douglas Humberto Urias-Orellana, his wife Sarah Ileana Gomez Mejia, and their minor child Geug are natives of El Salvador who entered the United States without authorization in 2021. After being placed in removal proceedings, petitioners applied for asylum. Under the Immigration and Nationality Act, INA, the U.S. government may grant asylum to a non-citizen if it determines that he is a refugee. Section 1158b1a. An asylum seeker qualifies as a refugee if he is unable or unwilling to return to his country of nationality because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. Section 1101A42A. In support of petitioners' applications for asylum, Urias-Orellana testified that he was being targeted by a hitman in El Salvador. The immigration judge, IJ, found Urias-Orellana's testimony credible, but concluded that it did not establish past persecution or a well-founded fear of future persecution under the INA. The IJ accordingly denied petitioners' asylum applications and ordered their removal. The Board of Immigration Appeals, BIA, affirmed. On petition for review, the U.S. Court of Appeals for the First Circuit also affirmed, holding that under the substantial evidence standard of review, the record did not compel a contrary finding. Held. The INA requires application of the substantial evidence standard to the agency's determination whether a given set of undisputed facts rises to the level of persecution under Section 1101A42A. Part A. Section 1252b4 sets forth the scope and standard of review for courts of appeals evaluating IJ and BIA removal orders. Subparagraph B provides that administrative findings of fact are conclusive unless any reasonable adjudicator would be compelled to conclude to the contrary. The court has previously interpreted this provision to prescribe a deferential substantial evidence standard, meaning such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. The courts of appeals have split over the extent to which this standard applies to the agency's determination that an asylum applicant has established persecution. Part B. Though the courts of appeals apply varying standards, the court has already concluded that the persecution determination, including both the underlying factual findings and the application of the INA to those findings, receives substantial evidence review. In INS versus Elias Zacharias, the court held that to obtain judicial reversal of the agency's persecution determination, an asylum applicant must show that the evidence presented was so compelling that no reasonable fact finder could fail to find the requisite fear of persecution. Congress amended the INA shortly after the court's decision, but those amendments, and the addition of Section 1252b4b in particular, codified the Elias Zacharias standard. The statute as it reads today therefore requires substantial evidence review. Part C. The court rejects petitioners' arguments that de novo review should apply because Section 1252b4b requires deference only for findings of fact, and no subparagraph explicitly addresses the mixed question of law and fact that is the determination of persecution. However, Elias Zacharias and the subsequent statutory history suggest that Congress meant for the entirety of this mixed determination to receive deference under Section 1252b4b. The court's decisions in Wilkinson v. Garland and Guerra-Lasparilla v. Barr are not to the contrary. These cases addressed whether a mixed question qualifies as a question of law exempt from Section 1252a's bar on judicial review, but whether a given issue is treated as a question of law exempt from the INA's jurisdiction stripping provisions says nothing about the type of review the court must afford to that issue under other provisions of the statute. Justice Jackson delivered the opinion for a unanimous court. Petitioners Douglas Humberto Urias-Orellana, his wife Sarah Ileana Gomez Mejia, and their minor child Geug are Salvadorian natives who sought asylum after entering the United States without authorization. An immigration judge, IJ, denied their applications and ordered their removal, determining that they had neither demonstrated past persecution nor established a well-founded fear of future persecution as required under the Immigration and Nationality Act, INA. After unsuccessfully challenging their removal order with the Board of Immigration Appeals, BIA, petitioners sought review in federal court. The Court of Appeals affirmed the BIA's ruling, holding that substantial evidence supported the agency's persecution determination. We granted certiorari to determine whether the Court of Appeals applied the appropriate standard of review under the INA. We conclude that the statute requires application of the substantial evidence standard to the agency's conclusion that a given set of undisputed facts does not constitute persecution. Accordingly, we affirm. Part 1, Section A. Petitioners entered the United States without authorization in 2021. Soon after they arrived, the government served petitioners with notices to appear in federal immigration court for a removal hearing. When they appeared as scheduled in an immigration court in Boston, petitioners conceded their removability but claimed asylum, along with other forms of relief from removal that are no longer at issue. Petitioner Urias-Orellana was the sole witness at the removal hearing. He testified that a sicario, i.e. hitman, from his hometown had been targeting him since 2016. That year, the sicario shot 2 of Urias-Orellana's half-brothers and vowed to kill every member of his family. To escape the sicario's threats, Urias-Orellana, Gomez Mejia, and Geug relocated within El Salvador several times over the next few years. After each move, Urias-Orellana was threatened by men who demanded money and warned that they would leave him like his brothers if he did not pay up. One of the men even physically assaulted Urias-Orellana when he returned to his hometown for a brief visit. The last straw came soon after Urias-Orellana's fourth and final move in 2021, when he learned that men had been asking around town about the arrival of any newcomers. It was at this point that Urias-Orellana, Gomez Mejia, and Geug left El Salvador for the United States. Under the INA, the U.S. government may grant asylum to a non-citizen if it determines that he is a refugee. 8 U.S.C. Section 1158 B1a. An asylum seeker qualifies as a refugee and is thus eligible for asylum if he is unable or unwilling to return to his country of nationality because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. Section 1101A42A. An asylum seeker can submit an affirmative application to the Department of Homeland Security or raise asylum eligibility as a defense to removal proceedings before an IJ. Urias-Orellana and his family chose the latter path. When the government initiated removal proceedings against them, they defended by asserting asylum eligibility. The IJ credited Urias-Orellana's account of the facts but concluded that those facts were insufficient to establish either past persecution or a well-founded fear of future persecution. The IJ explained that under First Circuit precedent, death threats may establish past persecution only when they are so menacing as to cause significant actual suffering or harm. The IJ concluded that Urias-Orellana's past persecution claim failed under that standard as he had not submitted any medical, psychiatric, or physiological evaluations indicating that he had experienced such suffering or harm. The IJ further found that the evidence regarding Urias-Orellana's alleged fear of future persecution to be lacking. He observed that Urias-Orellana had successfully escaped danger after many of his relocations and that any risk resurfaced only when Urias-Orellana returned to his hometown or nearby areas. Given the dearth of evidence establishing past or future persecution, the IJ determined that Urias-Orellana did not qualify as a refugee eligible for asylum under Section 1101A42. The IJ determined that Gomez Mejia and Geug were likewise ineligible for asylum as their claims were derivative of Urias-Orellana's, so the IJ ordered all three petitioners' removal. Section B. Petitioners appealed the IJ's ruling to the BIA. But the BIA affirmed the IJ's conclusion that Urias-Orellana's testimony did not establish that he suffered past harm in the aggregate rising to the level of persecution. It also agreed that because Urias-Orellana only had problems when he returned to his hometown, his testimony did not establish a well-founded fear of future persecution. Petitioners then sought further review in the U.S. Court of Appeals for the First Circuit pursuant to 8 U.S.C. Section 1252b2. Petitioners did not dispute that death threats may establish past persecution only when they are so menacing as to cause significant actual suffering or harm. Instead, they argued that the undisputed facts of this case met that standard. The Court of Appeals emphasized that its review was cabined to whether the agency conclusion that petitioners had not demonstrated past persecution or a well-founded fear of future persecution was supported by substantial evidence. Under that standard, reversal was warranted only if, in reviewing the record as a whole, any reasonable adjudicator would be compelled to conclude to the contrary. The Court of Appeals ultimately affirmed, concluding that Urias-Orellana's testimony did not compel a finding of either past persecution or a well-founded fear of future persecution. In particular, it determined that the agency reasonably concluded that the threats experienced by Urias-Orellana were not so menacing as to cause significant actual suffering or harm. It similarly determined that because Urias-Orellana was able to live in towns across El Salvador for years without harassment and only encountered difficulties once he returned to his hometown, a reasonable fact finder would not be compelled to find a well-founded fear of future persecution. We granted certiorari to evaluate whether the Court of Appeals applied the appropriate standard of review when evaluating Urias-Orellana's asylum claim. Footnote 1. Because petitioners have not challenged the standard of persecution that the agency applied, i.e., that death threats are sufficient to establish past persecution only when they are so menacing as to cause significant actual suffering or harm, we consider only the appropriate standard of review for the agency's application of that standard to the facts. We note the Solicitor General agrees with petitioners that purely legal questions about the appropriate standard of persecution are subject to de novo review. Carrying on. Part 2. Section 1252b4 does not use the phrase substantial evidence, but it does specifically address the scope and standard for review that the courts of appeals must apply when evaluating IJ and BIA removal orders. As relevant here, each of Section 1252b4's 4 subparagraphs truncate the court's review in a particular manner. Subparagraph A states that the Court of Appeals shall decide the petition only on the administrative record on which the order of removal is based. Subparagraph C says that a decision by the agency that a non-citizen is not eligible for admission to the United States is conclusive unless manifestly contrary to law. And per subparagraph D, the Attorney General's discretionary judgment whether to grant relief under Section 1158A of this title shall be conclusive unless manifestly contrary to the law and an abuse of discretion. This case involves subparagraph B, which provides that the administrative findings of fact are conclusive unless any reasonable adjudicator would be compelled to conclude to the contrary. This court has previously interpreted subparagraph B to prescribe a deferential, substantial evidence standard for review of agency factual findings. Substantial evidence, we have long emphasized, is more than a mere scintilla, but means and means only such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. Or, to come full circle, findings of fact are conclusive unless any reasonable adjudicator would be compelled to conclude to the contrary. Whether a given agency determination fits within the purview of subparagraph B and is thus reviewed for substantial evidence is not always clear. Indeed, the courts of appeals have split over the standard of review that should apply to the agency's determination that an asylum applicant has not established past persecution or a well-founded fear of future persecution within the meaning of Section 1101A42A. Some courts review the entire inquiry, both the underlying factual findings about what happened to the applicant in her home country and the agency's application of the statute to those findings, under the substantial evidence standard. Footnote 2. This is just a citation to a number of cases to that effect, so I'm not going to read them all out. Carrying on. Other courts break down the inquiry into two parts, reviewing the agency's factual findings for substantial evidence and its legal conclusions de novo. Footnote 3. There's just a number of citations to cases to that effect, so I'm not going to read them all out either. Carrying on. Yet even those courts are not always careful when differentiating between factual findings and the application of law to those findings, sometimes applying substantial evidence review to the entire inquiry. Footnote 4. This is just a number of citations to cases to that effect, so I'm not going to read them all out either. Carrying on. Today, we resolve the proper standard question as it relates to the Courts of Appeals review of the agency's persecution determination. As explained in Part 3 Infra, we hold that Section 1252b4b requires courts to review the entirety of the agency's conclusions, both the underlying factual findings and the application of the INA to those findings, for substantial evidence. Thus, in the language of the statute, the agency's determination whether a given set of undisputed facts raises to the level of persecution under Section 1101A42A is generally conclusive unless any reasonable adjudicator would be compelled to conclude to the contrary. Part 3. Though the courts of appeals apply varying standards to the agency's persecution determination, we have already concluded that these determinations receive substantial evidence review. Specifically, in INS versus Urias-Zacharias, we held that to obtain judicial reversal of the agency's persecution determination, an asylum applicant must show that the evidence he presented was so compelling that no reasonable fact finder could fail to find the requisite fear of persecution. To be sure, Congress amended the INA shortly after our decision, but those amendments, and the addition of Section 1252b4 in particular, codified the Urias-Zacharias standard. As such, the statute as it reads today requires substantial evidence review for the entirety of the persecution determination. Section A. Like this case, Urias-Zacharias began with an IJ's determination that a non-citizen was ineligible for asylum. Urias-Zacharias had testified that he feared retaliation in his home country of Guatemala after he refused to join a group of guerrillas who had attempted to recruit him. But the IJ concluded that this testimony failed to demonstrate persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion, as the INA requires. After the BIA affirmed, Urias-Zacharias sought review in federal court. The Court of Appeals sided with Urias-Zacharias, holding that a guerrilla organization's attempt to conscript a person into its military forces necessarily constitutes persecution on account of political opinion because the person resisting forced recruitment is expressing a political opinion hostile to the persecutor. We reversed the Court of Appeals, however, reading the INA to require substantial evidence review. The version of the INA in place at the time of our decision did not contain what is now Section 1252b4b, but it contained a similar provision which specified that agency findings of fact, if supported by reasonable, substantial, and probative evidence on the record considered as a whole, shall be conclusive. We interpreted that provision to require substantial evidence review of the BIA's determination that Urias-Zacharias was ineligible for asylum. More specifically, we explained that the provision set forth the substantial evidence standard for review, allowing reversal only if the evidence presented was such that a reasonable fact finder would have to conclude that the requisite fear of persecution existed. Though we did not specifically use the term substantial evidence, our explanation accorded with how we have long understood that standard to apply in the administrative context. We then went on to apply the substantial evidence standard to the entirety of the agency's persecution determination, including its conclusion that Urias-Zacharias' testimony did not satisfy the legal standard for persecution. We explained that Urias-Zacharias had failed to establish a well-founded fear that the guerrillas would persecute him because of his political opinion, with the degree of clarity necessary to permit reversal of a BIA finding to the contrary. In other words, even accepting his allegations as true, they were not so compelling that no reasonable fact finder could fail to find the requisite fear of persecution. Urias-Zacharias thus clarified that the INA's provision for substantial evidence review encompassed not only the agency's factual findings, but also the application of those findings to the statutory standard for persecution. Indeed, following our decision, the courts of appeals overwhelmingly understood it to require substantial evidence review of the entirety of the persecution determination. Footnote 5. This is just a citation to a number of cases to that effect, so I'm not going to read them all out. Carrying on. Section B. Just a few years after we decided Urias-Zacharias, Congress passed the Illegal Immigration Reform and Immigrant Responsibility Act of 1996, IRIRA, amending several provisions of the INA governing judicial review. Among other things, IRIRA added Section 1252b4, clarifying the relevant standards of review for IJ and BIA removal orders, but Section 1252b4 did not depart from our decision in Urias-Zacharias. To the contrary, Section 1252b4 stayed the course. Indeed, subparagraph B largely tracks our opinion in Urias-Zacharias. Compare Section 1252b4b, providing that administrative findings of fact are conclusive unless any reasonable adjudicator would be compelled to conclude to the contrary, with 504 U.S. at 483 through 484, stating that if an asylum applicant seeks to obtain judicial reversal of the BIA's determination, he must show that the evidence he presented was so compelling that no reasonable fact finder could fail to find the requisite fear of persecution. Thus, Section 1252b4b effectively restates the pre-IRIRA practice of applying the INA's deferential standard for factual findings to the persecution determination. Supporting this reading of Section 1252b4 are IRIRA's other amendments to the INA, which tend to restrict, rather than expand, review of immigration-related determinations in federal court. IRIRA added, for instance, Section 1252a2d, which strips courts of jurisdiction to review certain types of removal orders entirely, restoring jurisdiction only for constitutional claims or questions of law. IRIRA similarly limited the scope of review under Section 1252b4 even in the areas where courts retain their jurisdiction over removal orders. Not only does subparagraph B require deference towards administrative findings of fact, but subparagraphs C and D mandate that certain agency determinations are conclusive unless manifestly contrary to law. Against this backdrop, it would make little sense to interpret subparagraph B as expanding judicial review beyond the pre-IRIRA practice of applying deference to agency persecution determinations. Part 4. Given the force of Urias-Zacharias and IRIRA's enactment history, we cannot accept petitioners' arguments about the applicable standard of review. Petitioners primarily contend that Congress meant for de novo review to apply to persecution determinations because Section 1252b4b requires deference only for findings of fact, and no subparagraph of Section 1252b4 explicitly addresses the mixed question of law and fact that is the determination of past persecution and fear of future persecution. With their focus on the metaphorical trees, we think petitioners have missed the forest. It is certainly true that the required persecution determination turns on more than just the facts. The INA's legal standard for persecution must be applied to the IJ's findings of fact. But Urias-Zacharias and the subsequent statutory history suggest that Congress meant for the entirety of this kind of mixed determination, including both the IJ's factual findings and the application of the statute to those findings, to receive deference under Section 1252b4b. That makes sense because the overall determination of refugee status primarily requires the IJ to make critical factual findings about a given applicant's experiences in his country of nationality. And even where, as here, the IJ accepts the applicant's testimony as true, the IJ must make an antecedent determination on the factual question of the applicant's credibility. Given that Congress has required the courts of appeals to give significant deference to IJ fact-finding throughout Section 1252b4, it would be anomalous indeed to conclude that courts can review substantially similar persecution-related findings de novo. Footnote 6. Our conclusion that Section 1252b4b applies to the persecution determination and sets forth a deferential standard of review means we need not address petitioners' argument about Loper-Bright Enterprises versus Raimondo. That decision is not applicable when a particular statute mandates deferential review or otherwise delegates authority to an agency consistent with the constitutional limits. Carrying on. Our decisions in Wilkinson versus Garland and Guerrero-Lasprilla versus Barr are not to the contrary. In those cases, we held that a mixed question of law and fact could qualify as a question of law exempt from Section 1252A's bar on judicial review. But unlike Section 1252B, Section 1252A does not speak to the standards of review for removal orders. Rather, it addresses a court's ability to review removal orders at all. As a result, whether a given issue is treated as a question of law exempt from the INA's jurisdiction stripping provisions tells us nothing about the type of review the court must afford to that issue under other provisions of the statute. Neither case, then, requires de novo review here. Because the Court of Appeals applied the appropriate standard under Section 1252b4b when it reviewed the agency persecution determination for substantial evidence, the judgment below is affirmed. It is so ordered. And that does it for the opinion in this case. Yet again, another unanimous opinion of the court. Yet again, seems pretty straightforward to me. Yeah, it seems to me the statute is, very clear that it requires this substantial evidence review for questions of fact or agency determinations of fact. And then really the only question is, well, does that apply to this specific mixed question of law and fact, namely the finding of persecution or not? And, well, the answer is pretty straightforward. The court says, we've already said yes. We've already said that it does. We said so in Urias-Zacharias, and the statute was amended after Urias-Zacharias, but it was not amended in a way that displaced that opinion. In fact, it was amended in a way that incorporated that opinion into the statute. So why on earth would we deviate from that here? That reasoning makes sense to me. Not only do you have Supreme Court precedent on point, but you have Supreme Court precedent that Congress legislated against, in the backdrop, and seemingly obviously incorporated into the plain text of the statute. So yeah, that's it. it's I don't see how you come to a different conclusion here, and apparently neither did any of the justices on the court. And just about the only other thing that I have to say about this opinion is, well, it was a Jackson opinion, and it read like a Jackson opinion in a way that I'm not a huge fan of. She seems to just constantly refer back to, the section, subsection, subparagraph, whatever of the statutory provision that you're talking about, just constant repetitions of section 1252b4b just over and over and over again. It's like, we know what statute we're talking about. Can we just say the statute or, subparagraph B or whatever? Can we just shorten that a little bit? Do we have to keep referring back to the same section 1252b4b over and over again? I don't know. Maybe that's more a gripe for me because I have to constantly read it, out loud. Whereas if I were just reading it in the text, it wouldn't be that big of a deal. But I don't know. It just bugs me a little bit. She also seems to do a lot less in-text citations. A lot of citations are handled in footnotes, which, on the one hand, that's kind of nice because I don't really like how many citations and in-text citations the justices do a lot of the times. It's kind of annoying when you're reading the opinions either aloud or just, reading them silently for yourself to have to try and navigate, okay, what's citation and what is, actual, text of the opinion, because just the way the in-text citations are done, there's not obvious breaks between them all the time. But then it's kind of annoying to be like, oh, there's a footnote here. Oh, it's just more citations. Okay. But I don't know. Her opinions read, kind of distinctively compared to a lot of the other justices in this in these particular ways. I don't know if it's necessarily good or bad. Her opinions tend to be easier for me to read, at least, than Sotomayor's opinions, so I guess that's good. Um, and this one, in the last episode, I griped about Sotomayor uh, writing a lot more than was necessary, including just completely irrelevant stuff or unnecessary background or whatever. Um, Jackson didn't do a lot of that here, although the background of the Elias Zacharias case I thought was a little unnecessary. So, still some trimming that can be done, although it's probably true of most of the court's opinions nowadays, is that basically all of them include some degree of unnecessary just fluff, some more than others, though. But with that said, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts. And if you would like to support it, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members get access to bonus and exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we'll continue on through the Supreme Court's 2025 term. Until then.